All right, as promised, we're going to open this up for questions. We have handheld mics, so please don't be shy. Raise your hand, and
I'm Marty Lobel.
Thank you, Marty.
I just had a question about the constitutionality of some of these proposals in light of the Supreme Court decision in Goldberg versus Sweet, which dealt with where you could bill telephone calls. What are the limits, if any, on a state's decision as to a rational connection between the cloud and where it ought to be billed, unless Congress, of course, preempts it?
Well, it just strikes me that Goldberg versus Sweet had a 2 out of 3 test. Either, it was a case involving, long-distance telephone calls back in the 1990s, and the case said that the telephone call could be billed in one of 2 locations, either the location of the origin or the location of the destination, and the place to which the phone call was billed. It's got to be. The origin of the destination had to include the phone bill. With regard to cloud computing, I think that I don't think there's necessarily a problem, at least with regard to the software piece, because you're going to be using the software and billing it probably to one location, depending on how you source it. It might get a little fuzzier when you're using what I call the multiple points of use arrangement, but that's probably going to be a use tax, not a sales tax imposition. With regard to what I'll call consumer downloads of movies, music, and books, I think there could be a problem with Goldberg versus Sweet, because if my billing address is in Colorado and I'm downloading a song, or let's say a movie, to my laptop computer while I'm waiting for my plane at Dulles, and the movie is coming from a server in Texas, I would say that you don't have 2 out of 3 with regard to that. So there's a real question in my mind as to whether any state has a significant connection to that transaction to impose a sales or use tax on it. Am I right?
I would agree.
Quick practical question. I'm Jim Cately.
Thank you, Jim.
As a consumer of this service, should I care where the service provider is located jurisdictionally and subject?
Well, yes, I think you do care, because you don't want all 3 of the states trying to impose their sales tax on you. Colorado, where your billing address is,
Yeah.
Virginia, where Dulles is, or Texas, where the movie came from.
If you've got New York and Texas as the 2 jurisdictions at issue, they're both going to fight over it right now.
Will that affect me as a consumer? Are they going to bill me? Or I just
No,
from
from a practical standpoint,
standpoint,
all the states are going to go after the provider.
Right.
It's easier to, and they've got the money. But if a service provider gets in that quandary, he's going to start triple billing his customers.
Right.
One other question about data ownership. As a law firm, we want to insist on we own the data. And the question is, will that be relevant to the tax consequences, and will we get into a fight over that particular issue?
Is data tangible personal property?
It could be. I mean,
Could be.
It could
It's not
be.
software.
So, I mean, I think you want to retain the ownership to your data. I mean, that's critical. It's one of the legal considerations you have. So if you're putting your data in the cloud and the software is enabling, in our firm, like I think many firms use Citrix, right? You are able to put every matter and every document up in the cloud, and everything for Reed Smith happens to be in Columbus, Ohio. We don't even have an office in Ohio, but our server is there.
You have Nexus there?
I'll defer. But that's how a lot of firms are working, right? You put the server in some state, and then your attorneys all over the world are able to access it. Ohio is not a jurisdiction that's come out and has looked to the presence of data on a server to impose nexus. Some states, Texas, have. So from that standpoint, I think, But the problem is that you have a multiple server presence for data migration. I mean, very few people are using sort of one server provider, one server farm.
You get redundancy.
You get redundancy. Yeah. But it's interesting because one of the biggest server farms that was built in the North Panhandle of Texas. And you go and you see this facility, and it's just this huge, sprawling facility full of server mainframes. And Texas got wind of it and said, well, if everybody's going to come to North Texas and run up this AC bill, not where I would put a server farm, but that's where they did it. And then they looked to server presence for Nexus purposes. Well, I'm sure they will.
From Washington State's perspective, there's a specific legislative, basically safe harbor for data. If your only presence in Washington State is the data, then you do not create Nexus in Washington State.
And that's really the trend.
And of course, that's for competitive reasons. You want people using server farms in Washington State.
And that was definitely a legislative decision.
I was going to say, the Microsoft farm and the Amazon farm might have not benefited, but that is really sort of the default right now. It's a very minority of the states that are looking to server data ownership on servers located in the state.
David Bernori, I'm with State Tax Notes magazine and Tax Analysts. First of all, one comment and a question. The idea that data or software or other electrons flying around the universe are tangible personal property is one of the greatest legislative fictions ever created, in my opinion.
Well, can I just respond to that piece? If you stick your finger in an electric socket, can you feel that? Go ahead. I'm sorry.
Yes, but it is not tangible personal property in the delivery, in the traditional sense of how, and Cara alluded to this before, in the traditional sense of how we think about the sales tax. And if Bill Fox or John Mikesell or any of the other giants in the sales tax world were here, they'd say, they'd have a hard time identifying it as tangible personal property. That being said, back to the cloud for a minute, the pure sending, here's my question. The idea of cloud computing seems to me to be a business-to-business issue more than an individual issue. If I have my iPhone, I'm paying Verizon or AT&T or somebody for the service of using my iPhone, and I bought the phone from Apple and so on and so forth. I'm not really paying for the cloud. I'm paying for a service that may be utilizing the cloud. And I don't know if anybody thinks of it in those terms for individuals, consumers. As opposed to tax analysts, if we decide we're going to move all of our servers to Delaware or Cambodia or somewhere else and do all of keep all of our data there, and then that would be a business-to-business transaction. My understanding is most cloud computing issues tend to be business-to-business. So your clients, Kelley, either the vendors or the clients tend to be businesses and not individuals. And I want to know if that's correct, if my understanding is correct. And if it is, a bigger question, back to sales tax policy, is, there's a long history, if you study sales taxation, that business transactions really shouldn't be subject to sales taxes anyway. And I was wondering if that ever comes up, right? The idea that, again, standard sales tax theory is that businesses shouldn't pay sales taxes, consumers should.
I think that what you just said is one of the principal differences between a sales and use tax and a value-added tax. And I disagree that businesses don't pay these taxes. They pay
49% of all sales taxes collected in this country are collected by businesses.
They're paid by businesses.
Paid by businesses. That's different than whether it is correct from a theoretical tax.
From an economic standpoint,
yes.
Obviously the cost of that tax is going to get built into the product, and ultimately it's going to fall on someone who purchases for personal, family, or household use.
Unknowingly.
At the end of the day.
Well, no,
yes.
but that's the problem with the tax. That's
Yeah.
the problem with the structure of the tax as opposed to a VAT.
And that's
But-
not
so-
limited to digital products or
Right,
cloud computing.
right.
I mean, that's a general underlying debate within.
I agree,
sales
but
tax.
so my question though is this a consumer problem or is this a business-to-business problem? Is
I
really
think
my
it's
question.
both.
Both.
It's both.
I mean-
Let me give you an example of a product that I personally use. It's called SugarSync. And it allows me, I have a program on my desktop, on my laptop, and on my smartphone. And all of my documents that I have on my desktop, I can access from my laptop or my smartphone in the cloud. I think I pay $50 a year for that. And it's a consumer product. I think a competitor is called Dropbox. There's a bunch of, there's Carbonite. There's a number of companies that provide this service, and it's just marvelous, quite frankly.
But to be sure, a lot of our clients are clients that are buying Salesforce.com. Okay, you're absolutely right. One of the things that we really haven't touched on in the individual transaction thinking of cloud is that sometimes those transactions are in agreements guised as telecom taxes. Not to open that
Florida.
can of worms. Right, Florida is one of them. And so one of the problems we've encountered is when the agreement implicates telecom tax, but it's really not telecom that's being provided. But your example of you have an iPhone, it's serviced by Verizon, it's your service provider, and you're accessing iTunes. In those agreements, you'll see telecommunications as a consistent term when you're not really providing telecom if you're providing a cloud service, which can mucks up the water here unnecessarily. But I would say it's both, though. I mean, you're going to have many types of business-to-business cloud, especially as we move more into PaaS and IaaS, because there you're really buying network and data infrastructure and platforming, and individuals aren't really buying those services. Those are for the web designers and the developers and the programmers, as Mark is saying, at the
PaaS,
companies, right? For infrastructure, this ability to really manage your network. And IaaS is critical because IaaS gives you the most control over your data. So you want to talk about the issue law firms have is that we're all worried that the brief that we did for our client or the position as a tax attorney, oh gee, my opinion letter is going to now be subject to a breach. And so you want control, right? As we get more into PaaS and IaaS, I think you're seeing more of a control issue and ownership and service-based, a service-based product. But to be sure, you're still going to have these individual cloud issues. You just are.
But the individual cloud issue is less pronounced. If I'm buying something on my phone, if I'm buying iTunes,
Right.
I'm paying one person for the. I'm paying Apple for. I'm paying Apple for those iTunes, and so it really is a discrete transaction, and it really doesn't matter where those songs are coming from, whether they're coming from the cloud or from Mars. It doesn't really matter. I'm paying Apple, and the question is, should I pay tax on that on the purchase of my iTunes? Right? And that's pretty clear. We can debate whether we should or not, but that would be pretty clear to delineate, as opposed to a company offshoring their data processing or their data storage somewhere else seems to me to be a much more difficult question.
Well, first off, I think iTunes is not a cloud transaction, I don't believe. That's a download.
Didn't even know that.
They have a product called iCloud where you don't get a copy of the song. And the copy of the song stays up in the cloud. And whenever you want to listen to it, whatever it is you're using to listen to it goes up into the cloud and pulls it down. And you never get a copy of it.
I think to answer your question as well is that these technologies are certainly led, and the resources that go into developing them are in the B2B realm. And so that's why we're seeing this question, if you kind of accept where states have gone on the taxing of business inputs, for lack of a better description, that's where the development is. But we see the development of the consumer products coming from that, where 10 years ago, you might have thought about downloading a song, but you would have never thought of accessing a song in the cloud through that type of service. The things that are being worked on now in a B2B realm, the infrastructure as a service, the platform as a service, which are certainly, I think, B2B. From a state perspective, we're looking at where's the transaction, who's the consumer, who's the seller, how does that relationship work, how are they defining these products and services that are going back and forth, and then looking at, are these the types of things that there currently is an imposition on, and if there is, then the state needs to source it to the appropriate location. One of the things that Washington State provided is an excise tax advisory that provides kind of a decision tree, and it says, okay, first of all, is it a good or service? Well, that's pretty broad. Second, is it transferred electronically? Third, is there an exclusion from the definition of that digital product? If so, kick it out. You're not going to worry about it because that's a service not subject to sales tax. Then next, if it is a digital product, is it sourced to Washington? If it's not sourced to Washington, then a Washington customer doesn't need to worry about it. But when you get to that business-to-business realm, those questions have a lot more zeros behind them. And people care a lot more about those answers, but the analysis, I think, is generally the same, and it really comes down to, from a state's perspective, what's the transaction, who are the parties involved, what are they getting out of this, where are these definitions, because the definitions change as the technology changes. And so that's the struggle that states have, I think, in terms of changing business community definitions within a older tax statute. I think Washington State, we joke that it took us 70 years to complicate our TPP tax structure. It only took us 2 to complicate our digital products tax structure. But at the end of the day, the goal is to address those questions, to provide some sort of technically neutral approach that will address those issues as they arise, or at least give a framework for addressing those issues.
I'd like to make a comment about sourcing. It's something we haven't talked a whole lot about, and this sort of plays into the technology is always going to be a step ahead of the tax, and most state sourcing regimes sort of look to the location of the customer and require the seller to collect and remit the tax based on the seller's location, assuming nexus is that there's nexus. But we're entering into an age where a seller could sell something and have absolutely no information, number one, about where the purchaser is located. If I buy a downloaded product and I use PayPal to pay for the product, the seller gets nothing other than money. He has no idea who I am, where I am. The only thing he cares about is his money. And the seller may not know where the digital product is being transmitted from. He may have outsourced his electronic delivery function to a third party, and he may not have information as to where the third party's electronic distribution facilities are located, and the third party itself, for load balancing purposes, may not know exactly which server the product came from. So what is a seller to do when the sourcing hierarchy says, you usually start out with an over-the-counter transaction. You source it to the counter. If you're delivering a product, you source it to the delivery location, which really you don't have in an electronic environment because you're not shipping a product using UPS or FedEx. Usually you're sourcing to a billing address. And if you don't have a billing address, then you're in an origin sourcing type regime. And if you don't know where the product is coming from, how do you apply an origin source?
How do you even apply COP? I mean, I agree with you. I think that's sourcing and the income tax issues are really the issues that are yet to be determined. And the sales tax issues, they're really the issues where we're just seeing the state sort of catch up with issuing their guidance.
Horse named tomato.
That's right. That's right.
Question over here.
Hi there, Brian Bardwell, State Tax Notes also. David was kind of zooming out a second ago to the broader tax policy implications, and so I wanted to take that one step further. It's easy enough for the Washington Department of Revenue or whoever else to look at a sale of a Hershey bar and say, this is tangible personal property, we're going to tax that sale, and then look at the sale of, you know, an accountant's services or whatever and say, this is a sale of a service. But once we get to these things like Rhapsody and Pandora, where the technology is probably going to be just perpetually years ahead of what, you know, the regulators can write regulations for, does that distinction where it's such a judgment call, and I imagine that if 50 states were simultaneously picking up this issue, you know, you're not going to get everyone to agree. Does that start to suggest that there's a problem just with the way we're setting up this dichotomy and how we tax things? Like, are sales of services really so different from sales of tangible personal property that they deserve to be carved out from the law altogether?
I think from a state's perspective, I mean, every state has a slightly different approach to that, but I'll answer your question in two steps. First, just Washington itself, we just adopted our rule on this. It's Rule WAC 458-20-15503, and it does provide a framework that those types of taxpayers and the consumers can figure out where the tax structure is. I think we're out ahead of that one. I think, but in terms of states overall and how we address this, I mean, I think there's kind of two views on this, and this is where kind of the debate comes from. I think one is there's this underlying assumption that tangible personal property is subject to tax. And then there's this underlying assumption that services are not subject to sales tax. And now we have a realm of things that have a lot of the features and look and seem, well, to use a bad analogy, look and smell like services, but may feel, when you put your finger in the socket, like tangible personal property. And I think that states have to take that step of looking at these and deciding which way they're going to go. And I think that states overall are saying, you know, it still feels like the same thing you were getting from a tangible world's perspective. It's just now it's transferred electronically. And so I think states overall are looking at this and saying, well, it should be subject to tax, but how does that work from a legal standpoint? And I think that practitioners and the business community perhaps are looking at this and saying, no, these are services, they're coming from the services realm. And so we're meeting in the middle, and that's where I think the debate is really based on.
I'd like to respond to that.
Yeah. Really?
There's gambling going on at Rick's. I'm shocked. Traditionally, I mean, the sales tax grew up in the 1930s. I think Mississippi was the first state to adopt one. And traditionally, the sales tax was limited to sales of tangible personal property, and services were not taxed unless there was a specific imposition of the type of service. Let's say haircuts, barbershop services, you know, could be subject to tax. And the problem we have is that we have this new category of products that may be neither fish nor fowl. And the objection that the business community has to state revenue departments saying that this is a sale of tangible personal property and not the sale of a service is that the legislature has never considered the issue. And it's a serious problem, and it's, you know, some could characterize it as the executive branch of a state usurping the legislature's prerogative to decide what is taxable and what's not. Other people see it as a reasonable exercise of the interpretive power of the Revenue Department. I think it's a policy question for a state as to what should be subject to tax and what should not be, and the legislature should consider it. And those that haven't considered it and let the revenue departments run wild want the tax revenue and don't want to have to be seen as passing a tax increase.
it's also a real, I think, paradigm shift, because if we go even broader, I mean, we came from, at the turn of the last century, this agrarian manufacturing society to now a service-based society. And hasn't that been the argument raised so much in the recent debates of the states after in January, when we saw the State of the State addresses, where so many governors were saying we're going to expand the sales tax base. Some were saying income tax, but many were saying sales tax, and then turning to services. As an attorney, I'm very aware of several states that are at the precipice of passing legislation that's going to tax legal services and accounting services, which have heretofore been exempt. But we really are dancing on the head of a pin. To me, as a practitioner, when I look at Pandora, or I look at Twitter's new music launch service, and I look at that ability to do something that I see very akin to performance marketing. So to borrow off topic from our affiliate nexus topic, and we see what affiliate marketers do, you know, the issue there has always been in affiliate marketing, what are they doing? Are they selling very targeted advertising, or are they soliciting for the customer in the state? And that's been a key debate in the affiliate nexus arena, hasn't it? And I think it's a similar debate here with respect to services versus TPP, because I see that ability to performance market or behaviorally modify a suggestion, but use behavioral modification or personal preferences as the application of a very finely tuned product, a service-based product, reactive to the consumer's performance. And when you do that, I think you're not selling TPP, because I don't know what the TPP equivalent to that is.
Right. No.
That's the problem I have with it, I guess.
No,
And I think the states really do see that. But I wonder if we haven't, you know, passed the apex where now we are just simply becoming so much more of a service-based market, and less from that agrarian and manufacturing-based market that we had historically. That's where I sort of see it.
And I think from the state's perspective in general, this is a process that this move to this idea of a service product has already started with software. And I think that's why digital products is really seeing that mixture, because software, it was defined legislatively as TPP, and yet it is electrons. And so when you make that first step, the legislature looks at that, makes a policy decision that then says, okay, we've gone from this pure 1930s tangible personal property view to now that tangible personal property isn't so tangible anymore. And that, I think, has taken 20, 30 years to get to where we're at now, where we definitely have products that look like goods and services. And I agree with you. I think states are very cognizant of that, but have already seen this shift or this change in what's tangible. And that has led to these debates. And I think that cloud computing is a great forum for this, because it is it's a great buzzword. I mean, it just makes so much sense. It's a cloud. You don't know what's in it. You don't care what's in it as long as you get out of it what you want. And because of that, again, sometimes I'm going to want something tangible out of it. Sometimes I'm going to want a service out of it. Sometimes I'm going. How many people here have ever traded stock and looked at the stock prices and graphed that out and used a tool on the internet? Well, are you buying all of those stock prices and how it's gone up and down, or are you buying software that can take that data and make a nice chart for you, because everyone loves charts, or are you buying a chart, which is a tangible piece of paper if you print it out, or it's a series of electrons? And so cloud computing, I think, is the culmination of this trend, because it's not just pure software. How many times in the streamlined discussions, how many times in state discussions, in legislative sessions do people talk about, oh, well, software is taxable?
Software is taxable if you sell
it. But in terms of
what you sold isn't software, then you didn't sell software.
And so at what point are those things, again, like my example with the stock quotes, is it the software that you're selling that provides the graph, or is it the graph, or is it the underlying data that you're selling? And that's what states are grappling with right now in what do we do with that decision. And it goes much broader than that with the infrastructure as a service, platform as a service, and then you have the sourcing issues that we've discussed briefly, the nexus issues. In our legislature, one of the legislators said, this stuff is hard. And that was a pat on the back for everyone.
But even in your example, where
Yes.
you say that there's that bucket that's data processing, then a state like New York will come along and say, guess what?
Texas. Yeah.
Texas will come along too and say, guess what? Data processing is a taxable service,
But if the benefits were being received in another state, it's not
taxable, right?
Kelley, not to put you on the spot here, but you've mentioned at least twice the income tax issues. Could you briefly just highlight what you see as coming there?
Sure. I really think that, again, it's where the cloud service provider, the cloud service vendor is receiving income from subscriptions, and how they source that income. It's the apportionment issues. I also think here we have not just state issues, but I don't work with a client who's not global. I mean, these clients are all over the world. So while it's beyond the scope of this discussion, you certainly have international tax issues as well, with pulling that income back in. And is it connected to U.S. source income? You have Subpart F issues. Not to go down that road, but there are a myriad of, I think, income tax issues attuned to sourcing and apportionment that we're going to see. I mean, they're really.
One other international tax issue that we haven't spoken of course, is the value-added tax. And of course, the U.S. doesn't have one. Canada does. And for businesses, at least in theory, business doesn't pay value-added tax. It's basically a game of musical chairs with regard to tax dollars, and the last guy standing is the consumer. And in Europe, back in the 1990s, they recharacterized what I'll call downloads as the provision of a service. And that changed the location where the tax was due to an origin instead of a destination. So what all the U.S. companies were downloading stuff in Europe did is they set up all their downloads to come out of Luxembourg, which had the lowest VAT rate in Europe.
Or Malta.
Uh,
Malta, Grenada, and Luxembourg. But you're right, Luxembourg primarily.
Well, that's all changing. Come the 1/1/15, they're going back to a destination-based sourcing regime. So all the companies that sell downloads in Europe have to go rejigger all their tax compliance stuff, and the consumers are going to take it into shorts because they're no longer going to get the low Luxembourg rate. They're going to have to suck up the higher rate where they live.
20%, yeah.
I think we got time for one last question.
Hamilton State Tax Notes. The discussion just a moment ago made me wonder, is there any way to even coherently approach this when states still haven't, or anytime they try to address services without it being in the cloud, they move away from it. They're lobbied against taxing services generally. So it's strange that it's coming up in this it's just like kind of bypassed that whole thing and gone straight to the cloud, where we're talking about taxing things that are potentially services. That I'm just trying to see, can we have a coherent approach to this if that's not first addressed?
I just hope they don't solve it until my last kid is out of college.
I think it's more palatable in this arena. I think that when states expand when they broaden the base to tax newer services, it's not as palatable to the consumer in this context. Not that it is palatable here, but here we have the benefit of convenience. I can bite the burden of tax when I get that book on my Kindle in 2 seconds. I can bite the tax. The tax is more palpable on cloud services because of the convenience of what cloud services offer, arguably. So I think that's where, from a perspective of why is it so much easier for the states to go to services here, than say in the traditional services-based context.
You've got one state like South Dakota that taxes all services.
That's right.
And, doing it that way, I think probably helps keep their sales tax rate lower because they've got a broader base. My fear is that states aren't interested in lowering their overall rate by broadening the base. They're interested in spending the extra money.
Perhaps.
If I look at Rubber Band over here.
You deserve the last word. First of all, I'd like to thank all the tax analyst people. This doesn't happen without all of them. Thank our wonderful panel, and thank all of you for coming.
Thank you.